became evident that there was going to be a mistrial and a hung jury. We discussed it with the family of the victim. They did not want to go through another trial. We discussed a possible sentence that they agreed to, and we determined that that would be the best course of action at this time.
Does this plea in any way require any testimony from Schuyler Morris should Caleb Fernandez be charged in this case?
It does not.
Is there anything that you take away from the jury's long deliberations and ultimately the hung jury that in any way impacts any decision relating to his anything related to Caleb Fernandez?
We will take that into account, and we certainly don't know what occurred back in the jury room, so we really can't comment any further than that.
Can you comment or can you say that there has not been a decision not to charge Caleb Fernandez?
I can say there has not been a decision not to charge.
Okay.
We took very strongly into account the family's feelings. They felt strongly that they did not want to endure having to go through a wait for another trial and then another trial. And we balanced that with the fact that we had received a mistrial, a hung jury. 12 people did not agree on a verdict, so we balanced that and decided that the 17-year sentence would be what we would offer.
This is a somewhat unusual arrangement to have come together. Why ultimately did you decide to go forward with this agreement, and why so quickly?
Well, I have a 23-year-old young man that was facing life in prison, and he's going to be able to be out of prison probably in about 12 and a half years, and so he still has a life to live, and hopefully a very full life. This has been a tragedy from day one for everybody, and I just felt that it was in his best interest to take the lesser charge and be done, because with a hung jury, we don't know which way it would have gone. And in a retrial, you don't know which way it's going to go. And you're dealing with a young man that, again, faced life in prison. And I just didn't feel it was in his best interest to face that again.
How did he respond to having this offer come forward? Was this something that was a challenge for him? Did he seem to be amenable to it pretty quickly?
I don't think anybody's amenable to something where they have to go to prison for something that they feel they didn't do. And in our circumstance, we went through 5 days of trial, and 12 people couldn't agree one way or the other. And based on that, it's too risky to try that again.
Mm-hmm. Were there any discussions as you were working this out of whether he would potentially have to testify?
There is no requirement that he has to testify against anybody. And frankly, I don't think that he could testify against anybody, because we've maintained all along that he wasn't there.
Okay. And so was that ever brought up, or was that ever discussed, or is it just a non-starter because...
From the beginning, we have denied participating.
I'm talking within the last however long this just came together.
No, there is no requirement that he testify.
I mean, was it ever discussed?
No, not by me.
At what point in this 6 hours of deliberation did this start coming together? I mean, was this something that just happened within 10 minutes? Is it
I think as soon as we saw that the jury was having difficulty, I think I maintain an obligation to my client to the very end of the case. Mm-hmm. And when you see the jury's having difficulty coming to a resolution, I think it was time that the state and I had a serious discussion about the strengths of each of our cases. Mm-hmm. That we, obviously I didn't convince a jury he was not guilty, and the state couldn't convince a jury he was guilty. So at some point there had to be some negotiations.
And so that started right after the first note that they...
I don't remember what time. All the time's running together for me now. So.
Okay, but I mean, it was definitely into jury deliberations.
Oh, sure. Yeah, no, absolutely. Absolutely. I think if you've been here, you've seen how hard we fought all week. So, yeah, it was just, it was after we saw there was difficulty with the jury coming to a conclusion.
Did Schuyler at any point say, as you were doing this, say, I want to take some time to think about this, because this is something that happened very fast.
Of course, of course. But you have to understand, in any attorney-client relationship, we've been having discussions throughout of what it might take to feel this is in your best interest to take something rather than run the risk. So the discussions have always been held between he and I, as with any client. I always discuss these options and opportunities. And so he was well versed in the discussions. He just had to make a decision, and he felt he didn't want to go through this twice. And frankly, I can't blame him.